Hearing the appeal X against Kuoni Travel Ltd.
Good morning. I'm sorry we're sitting slightly late. Before we start, we make an order that no one shall publish or reveal the name or address of the appellant who is the subject of these proceedings, or indeed to publish or reveal any information which might be likely to lead to the identification of the appellant or any member of her family in connection with these proceedings. And no doubt Council will keep that in mind when making submissions. Now, Mr. Weir.
May it please your Lordship, my Lordships and my Lady. Here on behalf of the appellant, my learned friend Ms. Deal of Queen's Counsel, the respondent is represented by Mr. Audland of Queen's Counsel with Ms. Ross and Ms. Burin, and abter as intervener by Mr. Stevens of Queen's Counsel and Mr. Porkins. Lord, the appellant entered into a holiday contract with and only with the respondent tour operator and brings a claim for breach of that contract. Our primary case is that our claim starts and ends with the contract. And the secondary case is that to the extent that the defences in Regulation 15.2 of the 1992 regulations are engaged, they do not avail the respondent. My Lord, I intend to follow broadly the structure of our case as set out at paragraph 8, reference for which is MS 80, and to save time I will not rehearse that which is set out in section 1, but refer back to parts of that section when working through the other sections. So, my Lord, can I start with section 2, which was the services that the respondent promised to provide carefully and in respect of which it's liable for breach of such promise, for which I make the following proposition. The respondent expressly promised to provide all the holiday services carefully and to a reasonable standard, such that a failure by what for present purposes I shall simply call a third party to deliver any holiday service carefully puts the respondent in breach of contract with the appellant. Lord, may I start with the holiday contract itself? That provides expressly for various services and holiday arrangements to be provided. Your Lordships and Ladyship may choose to go to the Statement of Facts and Issues at paragraph 5, which is at page 67, where they're both set out. The contract itself is in remarkably small print. It would be an achievement to read it successfully, but if the court is minded to try, pages 197 to 198, and I can direct you to where on the page you'll find the relevant passages. 197, middle column, middle of the way down, 2.2.
The wonderful thing about operating from a computer is you can enlarge the text. So where are we in 197?
197, middle column, halfway down, 2.2, our commitment to you. Your contract is with Kuoni Travel Ltd. We will arrange to provide you with the various services which form part of the holiday you book with us, etc. 198, right-hand column, down towards the bottom, 5.10. Our commitment to you for your holiday arrangements. I'm not going to read all that out because it's set out in a way which is easier, both in the judgment of the Court of Appeal and on page 67 in the Statement of Facts and Issues.
Yes, thank you.
The respondent expressly promised to provide the holiday arrangements to a reasonable standard, clause 5.10b. And as is common ground, by operation of Section 13 of the Supply of Goods and Services Act 1982, the reference for which is Authority 1, tab 10, page 456, it is a statutorily implied term that the respondent, and I emphasise and no other, was obliged to carry out those services with reasonable care and skill. That's agreed. The brochure is at MS 200, just beyond the contract. And the court will see on the left-hand side, it says all-inclusive in capital letters. The starring there, in the Court of Appeal it was accepted, it was a 4-star on the basis it couldn't be determined whether that was a copying issue or whether it's a 3.5-star, but we agreed in any event that nothing would turn on the half-star difference. The contract between the tour operator respondent and the hotel signifies it's a 4-star hotel. And Justice Longmore so found. So I'm going to call it a 4-star hotel subject to that wrinkle. Under English law, that which is set out in the brochure is a warranty. I'll just give you the reference to the leading case of Jarvis and Swans Tours per Lord Denning, which is Authority 2, tab 24 at 748C. And likewise under Regulation 6 of the 1992 Package Tour Regulations, which is at Authority 1, tab 10, page 431. May I make now the following 3 submissions. First submission is that those, what I will collectively call holiday services, that's the various services in the holiday arrangements 2.2 and 5.10b, covered all the services to be provided under the all-inclusive holiday. This follows from the fact that the appellant has entered into a contract for the all-inclusive holiday only with the respondent. It's set out already, it's common ground. That's with the respondent as the supplier, not the respondent acting as agent for the hotel. There was no contract between the appellant and the hotel. The respondent made the primary promise that all the holiday services would be provided carefully, whether or not those holiday services were provided by the respondent or by another. It's right to note that the contract at clause 5.10b provides that liability will be for fault by the respondent or that of our agents or suppliers. And if one goes back to the statement of facts and issues, which certainly for my part is the easiest source of seeing it, it's at page 67. It's
my copy is not paginated.
Of
my copy of the statement of facts and issues, I'm working off a different copy.
Oh, I'm sorry.
So I need the
Paragraph
I'm
5.
sorry, it's paragraph 5b of the statement of facts and issues. And that sets out clause 5.10b. And the court will see we will accept responsibility if, due to fault on our part or that of our agents, does the court have that?
Yes.
Our agents or suppliers. And the Court of Appeal majority held that the use of the word our limited the respondent's liability to fault on the part only of those in a contractual or promissory relationship with the respondent. And that's paragraphs 39 to 40 at MS 177. So So MS 177, I can invite the court to turn that up. This is what I'm calling the Court of Appeal Majority, the judgment of Master of the Rolls and Lady Justice Aspin. Para 39, reference is made to that word hour, page 177, my lord. At the top. And then they say, on the face of it, the word hour, which governs the word supplier, in clause 5.10b, denotes a direct contractual or promissory relationship between Kuoni and the supplier of the holiday arrangements. And that's then confirmed as their view in paragraph 40, which I do not propose to read out. But, my lord, once it's recognised that the respondent was promising that all the holiday services would be provided, there is no room for the respondent to limit its liability to services provided by it or those with which it's in a direct contractual or promissory relationship. This is ordinary English contractual law. See per Lord Diplock in the Photo Securicor case, which I would invite the court to turn up, please. It's a well-known passage. It's also quoted by Lord Justice Longmore, but can I invite the court to it? It's Authority 2, tab 31, page 951. 951. I'll return in due course to this case. It's the case, as the court may well recall, of a contract for security at a site, and the security employee, one Mr. Musgrove, started a fire, the effect of which was to burn down the factory. There was an exclusion clause. The question arose as to whether the exclusion clause in a pre-UCTA world bit. But before getting to that, Lord Diplock provided the clearest of statements of the law in relation to contract. At 951, starting at B to C, the first paragraph, picking it up around C, such a contract is the source of primary legal obligations upon each party to it to procure that whatever he has promised will be done, is done. And I'll ignore what's in parentheses, and continues, where what is promised will be done involves the doing of a physical act. Performance of the promise necessitates procuring a natural person to do it. But the legal relationship between the promisor and the natural person by whom the act is done, whether it's that of master and servant or principal and agent, or of parties to an independent subcontract, is generally irrelevant. If that person fails to do it in the manner in which the promisor has promised to procure it to be done, as for instance with reasonable care and skill, the promisor has failed to fulfill his own primary obligation. See also in a holiday context, outside of the 1992 regulations, the Wong Mi Wan decision of the Privy Council. We're in the same bundle, Authority 2, tab 34 this time, starting at page 988 in the sole judgment of Lord Slynn. The first issue for the Privy Council being to determine whether the company with which the holidaymaker contracted was the only contracting party, or whether it had been acting as agent for other parties and so didn't bear responsibility for all the actions. And it was held that the company with which she contracted had contracted in the Lord Diplock fashion to deliver the relevant services. And so if we pick it up at 988, just after C, there's reference to the British Wagon and Lee case, which we've included in the bundle. And then Lord Slynn continues, the fact that the supplier of services may under the contract arrange for some or all of them to be performed by others does not absolve the supplier from his contractual obligations. He may be liable if the service is performed without the exercise of due care and skill on the part of the subcontractor, just as he would be liable if the subcontractor failed to provide the service or failed to provide it in accordance with the terms of the contract.
In other words, your primary focus has to be on the nature and ambit of the undertaking given in the contract.
Just so.
How that is supplied is a question of, at best, secondary importance.
It's a detail that's of great importance to the person providing it, but it's the whole point of the promise is that the promisee is entitled to rely on the promise, much as you might expect. My Lord, can I just simply give the reference to this point is made again at 992E. The person doesn't even have to be in a promissory or contractual relationship. Their Lord then simply says at E, the first defendant, because this was having established this was the first defendant's obligation. So I'm at 992E, my Lord.
Yes.
In the middle of that paragraph, the first defendant's obligation under the contract that the services were provided with reasonable care and skill remains, even if some of the services were to be rendered by others, etc., and even if tortious liability may exist on the part of those others. It doesn't matter. It's a claim for breach of contract. That's the appellant's position, but the 1992 regulations for the avoidance of doubt on this issue make this equally clear. Under the regulations, our case is a case primarily for breach of contract, but for the avoidance of doubt, Regulation 15.1, which I'm going to invite the court to turn up, it's Authorities Volume 1, Tab 9, page 434. Obviously a regulation which is going to have to be read at some point, so we may as well start the process now. And it is one of those regulations, Regulation 15, which will pay repeated reading, certainly from my perspective. It has done.
It's now superseded, is that right?
Now superseded, my Lord. Regulation 16 of the new regs, which are in the bundle, but I'm not going to take you to them because we're dealing with this. Regulation 15.1 at 434 provides the other parties to the contract, which I can translate as agreed as the tour operator. So the tour operator is liable to the consumer for the proper performance of the obligations under the contract, irrespective of whether such obligations are to be performed by the tour operator or by other suppliers of services. And it continues, this won't affect that any remedy or right of action which the tour operator may have against those other suppliers of services. So that mirrors the position under English contract law. Regulation 15.5 at 435 provides, without prejudice to paragraph 3 and 4, which don't bite for these purposes above, liability under paragraphs 1 and 2 cannot be excluded by any contractual term. So for the avoidance of doubt, and to the extent necessary to turn to the regulations require that the word our, whether one say it's struck out or not matters not, but it's not to be read as limiting the liability of the promisor respondent to that of the actions of those with whom it is in a direct contractual or promissory relationship. And this much is entirely obvious when one simply takes an ordinary example. Very popular these days, activities like Pilates on holiday. And Pilates will invariably, forgive me for giving evidence, but invariably be provided by a self-employed Pilates instructor. And so you can have a tour operator which may contract with another organisation within a tour operation group of companies, that's not unusual, which may go to another company, which may go to the owner of the hotel, which may go to the operator of the hotel, which may independently contract with the Pilates instructor. None of it matters. If you've been promised Pilates on your holiday, as part of your holiday, then the Pilates instruction has to be delivered with reasonable care and skill. And the tortuous or not contractual relationship to take you from Pilates instructor to respondent is neither here nor there. Indeed, there does not have to be a contractual relationship. It would appear, although this is a work of inference, that in the Jarvis and Swan Tours case, in which yodeling was promised, there's a description from Lord Denning that the yodeler left from work in his
All smacks
work
of personal
uniform.
experience on your part, Mr. Ware.
Less the giving of evidence on this occasion, my lord. More just drawing of inferences. But it said the yodeler had left work, and it may be the yodeler chose to give his services voluntarily. Not very well, as it would appear, because it ended up being a breach of contract, partly as a result of the poor yodeling services. But it doesn't matter. That's the point. It doesn't even have to be a contractual chain of relationship. My lord, no doubt for this reason, the respondent has conceded that the Court of Appeal, with the greatest respect, erred in relation to this point. It's paragraph 95 of its case at MS 132. And as always, if I've got it wrong and misunderstood the position, then I apologise, but it's pretty clearly put at 132, para 95, right at the bottom. There's internal numbering 28 from my Lord Lloyd-Jones, but it's external numbering 132. The respondent concedes there's no need to read our suppliers or other suppliers of services so as to limit its ambit to those in a direct contractual relationship. ABTA, perhaps with a slightly greater degree of diffidence, but using the word maybe, paragraph 43 at MS 156. Notwithstanding the view of the majority in the Court of Appeal, and with respect, it may be that another supplier of services includes also other contractors in the contractual chain. So that's a sort of partial concession, and I'll leave it where it lies, because you have our case. Lord, the second submission I make is this court is obliged to construe the express words of the contract, in particular various services and holiday arrangements, in the ordinary way, by which I mean taking into account the words used in the contract, the surrounding circumstances known to both parties at the time of the contract, common sense, and the reasonable reader or reasonable parties. And I've taken that for convenience from the Marks and Spencers and BNP Paribas case per Lord Neuberger at paragraph 27. And my Lord, that is Authorities Bundle 2, tab 27, page 856. 27, 856. Page 856. Now, this is the well-known case. I won't propose to rehearse its facts. Paragraph 27. This is Lord Neuberger focusing on the issue of implied terms, but as a precursor to that, he sets out, and for the moment to take you just to 27, of course, it's fair to say the factors to be taken account on an issue of construction, namely, hence by reading out the words used in the contract, surrounding circumstances, etc., those being the matters to be taken into account on an issue of construction. Construing the express words comes before implying terms into the contract. See again per Lord Neuberger, but this time paragraph 28. Most, possibly all, disputes about whether a term should be implied into a contract, it's only after the process of construing express words is complete that the issue of the implied term falls to be considered. Echoed by my Lord Hodge in a trump against Scottish Minister's judgment. The court's task is not, therefore, as the respondent now submits, to determine whether there's an implied term in the contract for guiding.
Your case isn't based on implied terms at all.
No, my lord, it's based on express terms. Various services, holiday arrangements. The court's role is to attribute the true meaning to that language, the language in which the parties have expressed themselves in their contract, and that's Lord Neuberger at para 29, quoting from Bingham MR, as he calls me. That's right not to have any pronoun, just Bingham MR, but that's how Lord Neuberger's put it, so I assume that's the right way. Over the page, he's quoted, as he says, as Bingham MR trenchantly explained in the Phillips case, para 29, the job of the court is to attribute the true meaning to the language in which the parties themselves have expressed their contract. And the appellant would note that the majority in the Court of Appeal approached matters on the basis that its task was to construe the words holiday arrangements. That's paragraph 34 at MS 175. I invite the Court to turn that up, please. MS 175, paragraph 34, at the bottom. The conclusion that the majority in the Court of Appeal reaches the meaning, we with great respect take issue with, but this is a different point. It's a preliminary point, which is right at the bottom. They say, we agree with the judge's conclusion on that interpretation of the expression holiday arrangements. In other words, that is the court's task. Lord, our third submission is that when construing those words, various services and holiday arrangements, the court should have regard to the following rules of construction. And the first is, by virtue of Regulation 7.2 of the Unfair Terms in Consumer Contracts Regulations 1999, if there is any doubt about the meaning of a written term, the interpretation which is most favourable to the consumer shall prevail. And that regulation is to be found in Authority Volume 1, tab 12, page 487. So it's 112.487. The respondent, before I go to Reg 7, the respondent does not contend that the regulations don't apply, but instead that they're not relevant because the appellant's claim relies on implying a term. But it doesn't. Regulation 7.2, one can see at the bottom of 487. We are in this regulation because we have a consumer as against a supplier dealing through a business. If there's doubt about the meaning of a written term, the interpretation most favourable to consumer shall prevail. And you can see, looking across at Regulation 12, is naught to do with it.
And could you please just elaborate for me in a few words how this relates to the regulations themselves and the implementation in those regulations of the directive? What is the relationship?
The 1992 package regulation?
Yes, indeed.
My Lord, I can in this way, if I may. Can I go backwards to go forwards? Can I invite the court in Authority Bundle 1, tab 1, to page 298. So I'm now in the EC directive on package travel, package holidays and package tours, as you see at 296. And I'm just at the end of the preamble, so I'm right at the top of 298. Right at the top of 298. The last preamble provides, whereas member states should be at liberty to adopt or retain more stringent provisions relating to package travel for the purposes of protecting the consumer. And then it continues, if the court will kindly go to page 301, to make good that recital by way of Article 8, albeit oddly it uses the word return rather than retain. And so it says, member states shall adopt or return more stringent provisions in the field covered by this directive to protect the consumer.
Which article is that?
Article 8, my Lord, page 301. Does your Lordship have it? Page 301.
So you say, insofar as ACTA imposes a more severe term on the holiday operator, that is entirely consistent with the directive?
Entirely consistent. The regulation, it's agreed, I mean, it's word for word, so far as Regulation 15.1 is lifted from Article 5 of the directive. Article 5 itself reads back into Article 4 for force majeure, but it's all packaged out word for word into Regulation 15. So it's a direct copy of the directive. The directive comes into the world of package travel and says, in effect, these are the minimum standards
Yeah.
I wish you to maintain, but you, member states, may have more stringent standards. And we say, yes, ma'am.
No, I was waiting for the end of the sentence.
Sorry.
I was-
And we say we do via, and I'll come to the Unfair Contract Terms Act, UCTA, if I may call it that, UCTA in due course, and also the 1999 regulations.
I was going to say, I thought my Lord's question was directed to the presumption in Article 7.2 of the unfair terms in contracts regulations, and I understood there was some jurisprudence of the Court of Justice about the application of a similar presumption in the case of PTR.
Then it may be a more sophisticated question and I'm able to provide an answer to. Forgive me if I've
I'm sure it's bound to have been a more
missed the focus. But
No, maybe I misunderstood.
well, forgive me, my lady, but from our perspective, this is the 1999 regulations are domestic legislation. Starting at ground zero, it would be remarkable if consumer protection legislation and the package travel regulations are that, had the effect of downgrading pre-existing rights to a consumer. That would be some achievement. So just intuitively or from ground zero, that is most unlikely to have taken place. In any event, the directive makes plain that more stringent rights are retained. At one level further on, in Regulation 15, and I was going to address this later, but I can address this now, my Lord, another way in which the two mesh. If one goes back to Regulation 15.1, which is at page 434, again, it's this continuous reading of what's actually been provided. It says the other party to the contract is liable to the consumer for, I put sort of highlight here, the proper performance of the obligations under the contract. And in 15.2, it says the other party to the contract is liable to the consumer for any damage caused to him by, and here I highlight, failure to perform the contract or the improper performance of the contract. In home and going places, which is in Authority Bundle 2 at tab 23, in the judgment of Lord Justice Longmore, who was in the Court of Appeal back in 2001.
The MS number.
I do apologise, Lord. It starts at 737, but I'm going to take you to 741. Lord Justice Longmore, in paragraphs 12, 13 and 15, explains that language requires the court to go to the contract. So you'll see 12 starts, the starting point must, in my view, be the contract which Mr. Home made with the defendants. And then I'm not going to use up time information, I'm going to take you straight down to 15. Right at the bottom, it is only possible to determine whether it's a case of improper performance by reference to the terms of the contract which is being performed. We've set this out in our case with the specific parts, but that's enough. So Regulation 15 does not impose upon that which the parties have contracted for, and so the 1999 regulations, which are an instrument of construction of the express terms that the parties have agreed, sits with Regulation 15, because Regulation 15, subject to Regulation 15.5, which can knock out contractual terms that seek to limit the effect of Regulations 15.1 and 2, doesn't speak to the content of the contract.
Well, how does that square with Article 5, which says that the member state shall take necessary steps to ensure that the organiser is liable to the consumer for the proper performance of the obligations arising from the contract, irrespective of whether or not such obligations are performed by that organiser, etc. So that's saying that whatever the contract says, the obligation imposed by the directive on the member state is to ensure compliance.
Lady, yes, that's the sort of second stage. The first stage is to understand what has been agreed. So is the holiday service limited in some way to simply providing very basic accommodation? Is it sophisticated five-star accommodation? What is it that's been provided? That's a matter of going to the contract. In relation to that, one turns to the 1999 regulations, which are an instrument of construction of that contract. If that contract tries to limit the liability of the tour operator to only those, for instance, in a contractual or promissory relationship, it will fall foul, one, of English contract law, and two, of Regulation 15.5, because it says you've got to accept liability for all the supply of the services that you've promised. So, Lord, I hope that addresses the question which has been asked.
Thank you.
And my Lord, the second, but by virtue of Regulation 7.2, far less significant point is that this is a contract drafted by the respondent, and so in the event of ambiguity, it has to be read contra proferentum. Lord, can I turn without further ado to Section 3 of our case, which was how N's offer of assistance and guiding of the appellant constituted performance of a holiday service. May I start with 3 preliminary submissions before addressing head-on the question of whether the services that are promised to provide included the service that N offered and provided to the appellant. And the first of those preliminary submissions is that following the Marks and Spencer's case, when construing those express words of the contract, various services and holiday arrangements, as regards the words used in the contract, the court is asked to note that the respondent promised that the holiday arrangements, including those ancillary to accommodation, would be provided to a reasonable standard. Standard was that of a 4-star hotel providing an all-inclusive holiday. And this point was well made in the case of Jarvis by Lord Justice Edmund Davies. And can I ask you to go back to I think it's the first time to the case, Authority 2, tab 24, page 750. 750. This was the case in which it was recognised that there should be non-pecuniary damage for loss of enjoyment, vexation, frustration in relation to a holiday contract. And in the judgment of Lord Justice Edmund Davies at C, after setting out some of the express terms, including yodeling, we come to, at C, does the court see, they went further than that. They assured and undertook to provide a holiday of a certain quality. And this was picked up by Lord Slynn in Wong Mi Wan. If you can move on to tab 34, to page 989. 989. Down the bottom at H. These questions have arisen in 3 English cases concerned with the provision of package tours. In Jarvis, the Court of Appeal held that travel agents had on the terms of their brochure made it clear they were contracting to provide was not merely air travel, hotel accommodation or meals of a certain standard. And then he quotes, they went further than that, they assured and undertook to provide a holiday of a certain quality. The holiday services here were not limited to the provision of, say, a self-catering accommodation, what I might call a bed for the night. That was not what was being promised. Second submission, a key surrounding circumstance known to both parties at the time of the contract was that this was a contract where the provision of pleasure or enjoyment was promised. Go back to Jarvis, please, at tab 24, page 749. 749. And I'm in the judgment of Lord Denning the previous page, 748, just while we're in it, between B and C, that's the reference to the statements in the brochure, representations or warranties. That's 748 B to C. That's while I'm there. Straight on from that, if I may. And now go to 749, just over the page at the top at A. There's been a consideration of which contracts give rise to non-pecuniary damage. And at the top, Lord Denning says, one such case is a contract for holiday or any other contract to provide entertainment and enjoyment. In the case called Watson Morrow, Lord Justice Ralph Gibson called it a contract for the promise of pleasure. And Lord Justice Stevenson in the same case at 752B. 752B. Further, the paragraph that starts, I further agree with my lords that the judge was wrong in taking, as I think he must have done, the amount the plaintiff agreed paid to the defendants for his holiday as the value of the holiday which they agreed to provide. They ought to have contemplated, and no doubt did contemplate, that he was accepting their offer of this holiday as an offer of something which would benefit him and which he would enjoy, etc. The importance of holidays to people was highlighted back in a CJEU case called Leitner by Advocate General Tisano at paragraph 43, which I'll very quickly go to if I may. It's Authority 1, tab 16, page 594. This was a case in which a child suffered from food poisoning on holiday and there was no remedy of non-pecuniary damage for loss of enjoyment in Germany, and it was held that the directive did confer such a right to damages. And para 43 is at page 594. And after the Advocate General was referred to, amongst others, Jarvis and Swan Tours, you see that in tab 23 in left-hand column. He gets to para 43. I don't propose to read it all out and invite the court to note it, but the end part, the very fact that holidays have assumed a specific socio-economic role and have become so important for an individual's quality of life means that their full and effective enjoyment represents in itself an asset worth enjoying. That's
protecting. Worth protecting.
I'm sorry if it's worth protecting.
And enjoying, I suppose.
My Lord, the third submission is that the holiday services include those services for the benefit of the customer which are actually provided to the customer on holiday. A point taken by the respondent and by ABTA is, well, you can't change what was promised by what someone chooses to give at a later stage. And in one context, that is readily understood, that point, but not in this context, because the respondent drafted the contract and elected not to set out, in minute detail, all of the services it would be providing. Not a criticism of the respondent, it's noting the reality. It would be peculiar, but it could have had a schedule running to many pages setting out all of these services which we provide, and it could even have had a schedule 2 that says we won't provide these ones. Could have done. But it didn't. What it promised to do was provide the various services that formed the all-inclusive holiday to a reasonable standard and with reasonable care and skill. And so those various services are in this sense not fixed at the time the contract is made, in the sense that the contract promises that such holiday services as are provided will be provided with reasonable care and skill and to a reasonable standard. By way of example, it may be that the holiday will provide a welcome drink, and it may be that it's not contractually obliged to provide a welcome drink. So it doesn't say in the brochure, you will have a welcome drink. And experience tells us that sometimes you turn up and there is a welcome drink, and sometimes you turn up and there is not. if there is a welcome drink and the waiter carelessly spills something on the customer or spills something on the floor and the customer trips or slips on the spillage as a result, then there will be liability. That is going to be operational negligence within the context of the services that have been promised. So merely saying at the date of the contract, I can't say precisely what services will be provided is not to hit the target. The target is to recognise that the actual services which are provided form part of the holiday services and need to be provided with reasonable care and skill. Turning now to N's actions and how they constituted the holiday services.
I was just going to point out that in paragraph 26, the Advocate General says that the provisions of the directive must be interpreted in the manner most favourable to the person whom they are intended to protect.
My lady, yes, it contains much the Leitner case, and I thought I would start with one paragraph, but my lady, yes, at paragraph 23, if we're in Leitner at 587, he says right in the middle on the right-hand column at 587, the obligations imposed on member states may be derogated from, but only in one direction, the direction of greater protection for the consumer. Your ladyship has referenced paragraph 26 at 588.
Thank you. Thank you. I didn't mean to take you out of your word.
My lady, no. But just as we're in it, at 607 in the judgment at para 22, the directive, and in particular Article 5 thereof, is designed to offer protection to consumers. Lady, whilst we're there, may I just take the court to one other part of that, which is the case of Blodel-Porlick. So we're in Authorities Bundle 1, tab 13, at page 498. So it's page 498, Authorities Bundle 1, tab 13, page 498, judgment of the court. This is a case in which a tour operator, due to fraud, became insolvent and the customer wanted his money back. And it was held that he should get his money back. Para 24 of the court, judgment at 498, moreover, such an interpretation of Article 7, and we're not Article 7, but it continues, is substantiated by the objective which that directive must pursue, which is to ensure a high level of protection for consumers. We've also included the Dillon Kofer case in the bundle, or it has been included, I can't remember by whom. My Lord, can I turn to N's actions and how they constituted holiday services? The appellant's case is as follows. With the three preliminary submissions in mind, first, the holiday services that the respondent promised have to be construed so as to deliver an enjoyable holiday of a standard befitting a 4-star hotel. Secondly, at a higher level of generality...
Sorry, you're going to have to slow down just a little bit.
It's an enjoyable holiday of a standard befitting a 4-star hotel. My Lord, at a second submission, at a higher level of generality, it can be said that the promise of various services included the service from hotel staff of providing assistance, brackets, with reasonable care and skill, to hotel guests with ordinary matters affecting them at the hotel as part of their holiday experience. That's providing assistance to hotel guests with ordinary matters affecting them at the hotel as part of their holiday experience. There will inevitably be a range of services, the common theme of which is that they are for the benefit of the customer. So one of the services will be provision of cleaning. That's the common parts and the customer's room. That is not an implied term of the contract. That is the court giving content to the express promise that there will be what I call holiday services, which is the various services and holiday arrangements. That's the court doing its job of construing the various services, which are all the services that constitute the holiday. Likewise, the provision of directing or guiding a customer about the hotel site will be part of the services contracted for. And they should be provided with reasonable care and skill. And that is a paradigm service ancillary to the provision of accommodation. The matter of common sense, and I invoke that because I'm allowed to when the court is construing these words, let alone against the backdrop of this being a contract for pleasure, it's a service that was promised. It's so obviously ancillary to accommodation. You get provided with accommodation, and I need to know my way about it. And this isn't accommodation that's go to one box and open it. This is hotel in hotel grounds. This is the hotel site or complex. That is a service which any member of hotel staff would be expected to provide, not just, say, reception staff. If the hotel staff member cannot assist, possibly because he or she can't even understand, it's a matter of language, the request, an example you've seen given in, I think, Abta's case of a gardener who's asked for directions, then reasonable care will have been taken without providing any direction or guiding on a given case. Where a hotel staff member offers up the service, then that's one of those services that has actually been provided, like the welcome drinks, and which must then be provided carefully.
You're saying that the offering of the service provides the content of the express term.
My Lord, I am saying that. Even if the service wasn't offered, if it was asked for, I would say it was a holiday service. I'm seeking to emphasise here that it was offered. So it's a fortiori, the position.
So is that changing the scope of the contractual obligation?
No, my Lord, that's the example I sought to give you of the welcome drinks. It's not saying I've changed the promises that I've originally contracted for. The promises to contracted for were that the services that are provided in due course will be provided with due care and skill, even though one can't say, well, is my room going to be cleaned twice in a 4-day trip, or every morning and evening? Is it at 2 o'clock in the afternoon when I happen to be wanting to rest? It doesn't work that way. It's the respondent's contract. In the event of ambiguity, re contra preferentum, but Regulation 7.2 anyway tells you, read it in the way most favourable to the consumer. That is a statutory obligation on this court. Need to give real substance to this, what I would describe as a hospitality contract. That's going back to, what's it for? It's for the benefit of the customer to enjoy themselves, to have a pleasurable experience. As a result, or as part of it, an integral part of which they're going to be assisted in ordinary things like being directed about the hotel site. It's not earth-shattering, it's ordinary. And see the analysis, I won't take you to it because I'm sure it would have been read, but the judgment of Lord Justice Longmore below, paragraphs 11 and 13, just give it a reference, 171 and 172, but I will keep going if I may. As regards the Court of Appeal majority's approach to construction of the words holiday arrangements, the Court of Appeal interpreted those words by reference to the function for which N was employed. And that's para 34 at MS 175, and then at para 35, the Court of Appeal held if N's actions were outside the ordinary course of his employment, they would be insufficiently connected with the acts he was authorised to do and so not fall within the holiday arrangements. Whereas I'm not going to invite the court to turn it up simply because I see the pressures of time already upon me. My Lord, that is to draw into the issue of construction of the contract between the appellant and the respondent the functions for which an employee of the hotel was employed. But that's the wrong approach. The hotel contract, the holiday contract, is not to be construed by reference to a contract of employment to which neither the appellant nor the respondent were parties. But you can't determine what the functions for which the employee of the hotel was employed unless you do so. Now, even adopting that approach, the Court of Appeal wrongly answered the question that they asked themselves. And we say that because, and here I will invite the court to go, to the House rules. Can the court kindly go to MS
268, I think.
I'm very grateful. 263. 263. These are the House rules in which, before it starts one, but second paragraph, so at 263, it says all employees are expected to act in conformity with these rules. And then if the court kindly goes to 267, Part 3 behaviour, part way down, 267, Part 3 behaviour. In our business, the big boss, it says in, but is the customer, etc. Our principal object should be to look after, serve him courteously, and make him comfortable. If that were not enough, next page 268, last paragraph. Lastly but not least, each one of you should take on the responsibility of being a salesman of our hotel. Learn all details of the various facilities available at the hotel so that you may guide the guests. Now, we understand that the interpretation of the contract between the appellant and the respondent does not have regard to a document to which neither was a party, but in responding to the Court of Appeal majority's approach, I will take you to this, and it is a feature of this case that the respondent shouts so loudly to say, what, guiding? In circumstances where the House rules are express that all employees at the hotel were required to learn where the facilities were so that they could guide people around the hotel. It also answers the question that the respondent makes so much of, namely whether the appellant can prove that M was authorised to provide guiding services. Because if, contrary to our case, it is right to put the question in that way, then the House rules show that he was authorised so to act. It also accords with the contract between the respondent and the hotel. At 285, again, frankly, impossible to read, but you have to turn it sideways, and you'll see, hopefully, at 2.6, this is the contract between the respondent tour operator and the hotel. 285 is sort of internal 122, but it's the MS is then put near the binder. Left-hand column near the top, 2 definitions. Down at 2.6, services, accommodation, facilities, amenity, food and drinks, and all kind of services provided for the benefit of clients at the hotel by the supplier and or agents or subcontractors.
Sorry, can you tell me again where that is?
Yes, my lord. It's left-hand column near the top. You see 2 definitions, and then the last definition, 2.6.
Yes, thank you.
And it actually says services, accommodation, facilities, amenities, food and drink, and all kinds of services provided for the benefit of the client at the hotel by the supplier and or agents or subcontractors. This is all very ordinary. This is exactly what one would expect. On the issue of attribution raised by the respondent in this case, the question is not one of attributing N's conduct to either the hotel or the respondent so as to establish that a contract was or was not formed, which is where almost all of the cases put into the bundle by the respondent take the court. It's not where the fraudulent director does something, does this bind his employer, the company. Here we have a contract which was in place before going on a holiday, a contract between the appellant and the respondent. And the question for this court is simply this, whether N, in offering the guiding services and taking her off the path, was providing a holiday service. My understanding of the approach taken by Lords Toulson and Lord Hodge in their joint judgment in Bilter and Nazir, obviously stand corrected wrong, by Lord Hodge or others, is that is how my Lord Hodge and Lord Toulson understood attribution in the context of a contract. Can I go to the Bilter and Nazir case? Its authority 2, tab 25, starts at page 816. This was just one of those cases where the claimant alleged fraud by its directors, and there's a question of whether the claimant was barred principally by illegality on the basis that the actions of the directors were attributable to the claimant company, so that the claimant was itself party to the fraud. And in the joint judgment of Lords Toulson and Hodge, page 816D deals with, and see the heading, attribution. And the position in contract is dealt with very shortly at 185. So that's 817, in which it's said, Lord Diplock stated the principles in a contractual context. And then the quote, which I've already taken the court to, from Lord Diplock in Photo Production Securicor. And then the judgment continues with vicarious liability and all sorts of issues of attribution in the particular context, which is the common context that I've already raised, having nothing to do with this case. Attribution is resolved in a contractual, if one wants to use the word attribution, it's resolved in exactly the way that we've always submitted by the principle in Photo Securicor. There is a contract. The promisor has promised that services will be delivered, brackets with reasonable care and skill, and if those services are not delivered, provided they are holiday services, they have to be holiday services, they have to be services under the contract. But if they're delivered carelessly by whomsoever, holiday services under contract, then there is liability on the promisor. It's a breach of contract by the promisor to the promisee. It's that simple.
Can I just ask you whether this is perhaps an over-elaborate way of looking at matters, and whether it wasn't simply possible for the court to say, under the contract, there was an obligation to provide accommodation that was safe, full stop, and so that one doesn't get into the elaboration of whether N was providing a service?
My lady, it's not the approach that we have adopted below, so I'm careful not to sort of jump onto something that may be helpful.
It's a general inquiry
to that end. Try to think which case it was. I think it was Hone, in which the point was made that there's not a warranty for safety in the contract. It's a warranty that the services will be provided with reasonable care and skill, and that is how we have always put the case, as opposed to a warranty for safety.
Mm-hmm.
Well, there can't be a warranty for absolute safety.
My lord, no, that's why it's not our case. Is it a holiday service? If so, it must be provided carefully. If it's not, forgive me for repetition, but the tour operator is liable in breach of contract to the appellant. The appellant's remedy being a classic breach of contract with the only person with whom she's contracted for all of the services.
So had N jumped out from behind a bush, that would have not been a holiday service. But because he
Yes,
offered to guide,
Yes, my lord.
you say it falls within the scope of the contract.
Absolutely.
Yeah.
We accepted that in the Court of Appeal. No difficulty with that at all. Because here, my lord, N was A, on duty, B, in uniform, C, on site, and D, offering and agreeing to provide, A, with a route to reception. So he was providing assistance with an ordinary matter affecting her at the hotel as part of her holiday experience, and his actions constituted performance of a relevant service. Simple.
And indeed performance of an obligation which under the House rules he was enjoined to provide.
Couldn't be clearer. And then we hear the complaints. What? You're trying to imply some very special term into a holiday contract.
But the House rules can't, under our approach to interpretation, be used as an aid to interpret.
We totally accept that, my lady. That's right. I introduced into court in response to the Court of Appeal's approach, which inevitably takes you to what are the functions of the employee, which are answered by the House rules in this particular context.
Well, in fact, you say you don't need to rely on the House rules at all, because this is obviously ancillary to the services that you would expect to be provided. But in order to rebut the notion that it is wholly exceptional that an electrician should be required to give guidance, you refer us to the statement that his employer has given.
Well, I do, and ABTA's intervened, and it's notable that having said they won't interfere in this part, they then have a nibble on this issue. But you don't see ABTA saying this is the position across all the contracts. This is in our role as ABTA responsibility, or the body for all of the tour operators. We can say there's none of that. None of that. It's just submission. This can't be right because we don't want to be liable. Understand that?
But if the contract had said expressly that the accommodation should be safe to a reasonable degree, then you could have relied on that term.
Absolutely. We take the contract as it comes. It's drafted by the tour operator. But it has to be in our favour. We made those submissions. Next submission on this issue, N's motive is irrelevant. Lord Justice Longmore so recognised at paragraph 12, I'll just give it a reference, MS 171. Now, I detour now into vicarious liability. This is not a case of vicarious liability, but it chimes with the approach taken by Lord Toulson in Mohammed, which is now the leading case on vicarious liability. At paragraph 48, which I'll ask you very briefly to turn up, it's Authority 2, tab 29, page 901. Yeah, just before the judgment of Lord Dyson, MR, page 901. Para 48, Mr. Khan, he was a talker. Mr. Khan's motive is irrelevant. It's what N did, not why he did it, that counts. Much play is made by the respondent. They're delighted that we recognised in our case that the judge said that N lured the appellant off the path. We recognise that that was what the judge said in his judgment. It doesn't matter. He took her off the path. Luring is taking someone off the path with an ill motive. But it's the taking off the path that counts. Represented to her that he was providing a service, as a result of which she left the safety of the path and followed him. But a different way, he offered to provide a holiday service which she accepted, and in this way, he was put in the position, the respondent was put in the position of being in breach of contract to the appellant if the service was not performed with reasonable care and skill.
Yes. How do you get round Judge McKenna's finding in paragraph 44 of his judgment that when N lured the claimant, he was not discharging any of the duties he was employed to do?
We're saying that's not a sort of clean finding of fact at first instance at all. That's a mistake of law because he's completely misconstrued the contract. So we start from entirely the wrong position. Entirely. I mean, with the greatest respect, it would be like investing too much time in the judgment and majority of the Court of Appeal, which shoots off on a track of saying, I'm going to interpret the contract by reference to regulations, which I will read in the most restrictive way I can. And we see that because they say that even if there's vicarious liability on the part of the hotel for operational negligence, still there's no liability under the contract. It's so remarkable, I must rein myself in and leave it where it lies and hope to show...
Well, I mean, I'm not looking at what the Court of Appeal did, I'm looking at what Judge McKenna did. But you say that one has to interpret that paragraph in the wider context, and you say that it's a conclusion which is tainted by an error of law, in effect.
Absolutely.
Yes,
oh, absolutely, my Lord, yes. Yes. Can I now turn, please, to section 4, which was how the index assault constitutes a failure to provide the holiday service carefully. May I make 3 submissions in relation to this? First is that N self-evidently didn't perform the service of guiding the appellant to reception with reasonable care and skill. And C, but I'll just give you the reference, Lord Justice Longmore, paragraph 13, which is MS 172. The second submission is the assault was a consequence of N being able to guide, or as the judge held, lure, the appellant off the path and was the breach of duty. It was breach of the holiday service. The assault was not the performance of the service, and it takes the respondent nowhere to make the obvious point that he didn't have authority to commit sexual assault. So there, paragraph 70 at MS 125. Third is the failure to perform the service was of an egregious and presumably criminal kind. I say presumably because the respondent has taken the point that it may have been insane, and I don't think it was prosecuted. Anyway, is not to the point. The failure consists in a failure to meet the standard promised by the respondent. In this case, the promise to perform the service with reasonable care and skill. The respondent's approach is as if to suggest that it is a criminal act means it cannot be a breach of duty. Well, Photo Securicor involved Mr. Musgrove, the security guard, being, in fact, he pleaded to a criminal offence. Authority 2, and if we can please turn this up, tab 31, page 933. 933. H. Musgrove subsequently pleaded guilty to the offence of maliciously damaging a building, stock and machinery contrary to section 51 of the Malicious Damage Act 1861. Just back on that issue of intention is not relevant. At 943, C to D, in a judgment of, or opinion then of Lord Wilberforce, 943, C to D, his full intentions hadn't been established, you'll see, but when inside he deliberately started a fire by throwing a match onto some cartons. The fire got out of control, a large part of the premises was burnt down. What he did was deliberate. It was not established that he intended to destroy the factory. None of this matters. And when we get to the opinion of Lord Diplock at 949H, down the bottom, it is not disputed that the act of Sir Cyrical's servant Musgrave in starting a fire in the factory which he had undertaken to protect was a breach of contract by Sir Cyrical. Of course it's not. And this point was well made, again, in a case that has a different context, but the point is the same, by Lord Denning in the case of Morris and Martin. This is the well-known case of a bailee of a mink stole. And that was the company that was the bailee of the mink stole, C.W. Martin. And the person to whom the bailee entrusted the cleaning of the stole stole it. And Lord Denning, at page 913C to D, looks at the case in a breach of contract position.
Repeat the page number, I'm sorry.
Lord, I'm sorry, it's 913.
913.
913. 913, C to D. If you go through the cases on this difficult subject, you will find that in the ultimate analysis, they depend on the nature of the duty owed by the master towards the person whose goods have been lost or damaged. If the master is under a duty to use due care to keep goods safely and protect them from theft and depredation, he cannot get rid of his responsibility by delegating his duty to another. If he entrusts that duty to his servant, he's answerable for the way in which the servant conducts himself therein, no matter whether the servant be negligent, fraudulent, or dishonest. The master is liable. So we have the sort of pre-photo Securical point. It actually doesn't even have to be the servant. It can be the servant, subcontractor, and so it can go on. It doesn't matter. But we also have the point which was drawn out in language befitting the age by Lord Justice Diplock when you go on to 921 at E, when he says, I can see no justification in reason or in morals for a rule of law which makes a bailee of goods for reward liable to the bailor for their loss if, as in Abraham's and Bullock, his servant to whom they are entrusted carelessly enables someone else to steal the goods, but protects the bailee from liability if that servant steals it himself. The greater the fault of the servant, the less the liability of the master. In other words, he's mocking the point, saying that can't be right, as he says, in justice or in morals. The breach can be trivial, the breach can be egregious. It's a breach. May I give a sort of workaday example of this? If we have a holiday in which, I'm going to keep it in England so that English law applies, and it's straightforward. If as a part of the contract in the ordinary way, there is provision for transport from the airport to the hotel by coach, and if the coach driver crashes the coach as a result of an act of momentary carelessness, that is what I've described as operational negligence, which shows that the service of transporting the claimant with reasonable care and skill has not been provided and would lead to a breach of contract. If the driver falls asleep and the coach crashes, assuming that there's carelessness for falling asleep as opposed to some narcolepsy for which he had no prior awareness, etc., then he may have committed the criminal offence of dangerous driving or not. But again, the service of driving with reasonable care and skill has not been provided. If the coach driver engages in an act of road rage and so shunts the coach into a car in front and the coach crashes, and it may be that someone dies and it may be manslaughter or whatever, or death by dangerous driving, whatever criminal offence one selects, it doesn't matter. Because from the perspective of the claimant, vis-à-vis the tour operator, the service of providing transport with reasonable care and skill has not been provided. So So it just doesn't matter. Well, may I move on to section 5, which is how the respondent cannot rely on a contractual exclusion clause. So this is our case as I opened. There's a case for breach of contract. Clause 510B, which again for these purposes I would propose one might use the statement of facts and issues, and it was paragraph 5.2 of Lloyd Jones, falls into two parts. So it's page 67, MS 67. And the first part is, we will accept responsibility if due to fault on our part or that of our agents or suppliers, any part of your holiday arrangements booked, etc., to part of the holiday arrangements, full stop. And the second part starts, we do not accept responsibility if and to the extent. The second part is an exclusion clause.
Why do you say that?
Because it is seeking, they've accepted responsibility under Part 1, and then they've sought to draw exclusions for their liability.
Yes, but in Part 1, they accept responsibility if due to the fault on our part or that of our agents and suppliers. And Part 2 really gives content to that qualification. I mean, absent fault on their part or that of their agent or suppliers, they are not warranting that the holiday arrangements will be to a reasonable standard.
My Lord, in one sense, may I respond in this way? Absolutely. And this goes to a confounding feature of the regulation, and I'll make my submission on this in due course as to why the regulation defences don't bite if there's been fault, because your Lordship is noting the sort of conflict in the sense that if there has been fault, there has been a breach of contract, and you can't get out of it. And that I tentatively submit is the force of the observation that my Lord Hodge is making.
Well, I'm not sure it is. I think what I'm saying is the second part of clause 510B gives content to what is being said in the first part, rather than operating as an exclusion.
Well, my Lord, the first part of 510B, once we recognise that the word our shouldn't be given the special content and meaning that the majority in the Court of Appeal attached to it, actually reduces to, we, under ordinary English law, see photo securical, we recognise that if any holiday service or arrangement isn't delivered with reasonable care and skill by any person who provides a holiday service, we're liable. And what
I don't know that you have to break down the two parts of 510.
It's all part of the same thing.
Yes, it's in its entirety a purported exclusion clause, isn't it?
My Lord, it may be that's one way of approaching.
Well, I don't see. Well, for the whole thing to be an exclusion clause, one would have to have a separate undertaking from which liability was excluded. This is the undertaking clause, and I rather than putting it as Lord Kerr put it, I would put it this way: that both parts of the clause are defining the extent of the tour operator's undertaking.
Yeah, well, I'm happy with that. I know there is a purported exclusion within the provision, but I don't think that there's any profit in following that somewhat esoteric discussion.
My Lord, may
I need a basis for I need from you a basis for saying that the second part is an exclusion clause. Because if it's not an exclusion clause, then certain parts of your submission are not relevant.
My Lord, yes. It's just in partial response to those observations, my Lord, there is another part of the contract that provides the primary obligation, because there was a promise to provide the various services under the contract.
That's 2.2, yes.
And Section 13 of the 1982 Act requires that those are provided with reasonable care and skill. My Lord, the majority Court of Appeal considered that it was an exclusion clause. That's Para 28, MS 174. The relevance of using the language of excluding is because this is a submission relating to the Unfair Contract Terms Act. And so what's key is it engaged or not?
Precisely.
And can I turn to that, which is Authority 1, tab 11, page 464, and then perhaps the submissions will be more grounded and less esoteric. So my lords and my ladies, starting at section 1, I don't think it's in dispute that we're dealing with an issue of negligence as defined at section 1(1)(a), because that's defined as an obligation arising from the express or implied terms of a contract, and that's the section 13 of the 1982 Act, to take reasonable care or exercise reasonable skill in the performance of a contract. So we then go to section 2(1), which is at 465, and that provides that a person cannot, by reference to any contract term, whether defined as an exclusion clause or not, exclude, that's what its effect is, or restrict his liability for death or personal injury resulting from negligence. And if one just takes a step back, it is English domestic law, see the photo security, one-way WAN, and so on and so forth, that is a promise that's binding on the promisor to ensure that all those services under the holiday are delivered with reasonable care and skill. Where personal injury results from a breach of that, liability has to follow, and no contractual clause can prevent that outcome. So that may be a more straightforward way of my making the submission. Indeed, the respondent's analysis is not to say that section 2(1) would not otherwise bite, but to say it doesn't bite because of the operation of section 29. And may I invite the court now to turn to that. It's at page 479. And they rely on either section 29, or both, section 29(1)(a) and section 29(1)(b. And so I need to take those in turn. Section 29(1)(a), that nothing in the Act removes or restricts the effect or prevents reliance upon any contractual provision which is authorised or required by the express terms or necessary implication of an enactment. In the respondent's case, it is authorised, not required, authorised by Regulation 15. That's the way they put their case. But, as I've already submitted, Regulation 15 follows completely the EC directive. The EC directive sets minimum standards, giving the member state the right to retain prior, more stringent standards, which we say this is one. And Regulation 15, which I'm now going to ask the court to go back to, which is Authority Bundle 1, tab 9, page 434, achieves its desired result in Regulation 15.2, so I'm at 434, by saying the other party to the contract is liable to the consumer for any damage, etc. That is a statutory cause of action. That is why Regulation 15.5 does not say these terms, including the statutory defence, will be incorporated into your contract. It does the opposite. Regulation 15.5 says if you don't have a contract achieving at least this, it'll be struck out. Contrast, for instance, if the court drops back to 432 and 433, MS 432 and 433, Regulation 9 and Regulation 10. Regulation 9.3, it is an implied condition of the contract, etc. Regulation 10.1, in every contract there's an implied term, And I should have shown you 431, which was the warranty point I made earlier, which should now pick up. Regulation 6. The particulars in the brochure shall constitute implied warranties, 6.1. Subject to regs, paras 2 and 3, which are not applicable. So it hasn't done it that way. What it has done is provide a statutory cause of action with a statutory defence. But this is an action for breach of contract. That is why the claimant was able to succeed in the Court of Appeal in the case of Wood and Toohey involving food poisoning, relying on Section 4.2 of the 1982 Act, Supplying Goods and Services Act, on the basis that food was goods and ownership in the food transfers to the customer, as the customer eats and destroys the food, so must have owned it, so the Court of Appeal held. And so the food not being of satisfactory quality, the implied term under Section 4.2, there was a breach of contract, in circumstances where the claim under the regs had been dismissed and was not pursued on appeal. See paragraphs 10 and 11, so I'll briefly take you to that if I may. It's Authority Bundle 2, tab 35, page 1001. That was Lord Justice Burnett, as he then was. And 10 and 11, you'll see at 10, the claimant failed to establish the hotel was at fault in the manner required by the 1992 regs. 11, it was in those circumstances the alternative case advanced by Mr. and Mrs. Wood failed to be considered, which was a case of a breach of contract relying on the statutory implied term under Section 4.2, and the claimant succeeded. This too is a claim for breach of contract. Going back to the Unfair Contract Terms Act, Section 29, and now looking at 29.1b, so that's at page 480. Forgive me for dipping out. .480 provides, so reading 29.1 again, nothing in this Act removes or restricts the effect or prevents reliance upon any contractual provision which, being made with a view to compliance with an international agreement to which the UK as a party does not operate more restrictively than is contemplated by the agreement. That is a reference to, for instance, the Hague-Visby rules, the Warsaw Convention, the Montreal Convention, C, and we've provided you with a small, tiny supplemental volume 4, won't take you to Chitty and Benjamin, but they're in there. They give those by way of examples. It's obviously a non-litigated section of the Unfair Contract Terms Act, but they rightly reference those agreements because, as this court well knows, the United Kingdom is, as often referred to as, a high contracting party to one of those international agreements or conventions. It is a member state, by contrast, of the EU, which through the directive, because that can be, so the international agreement can hardly be the regulation, so it must one infers be the directive, is not an international agreement, it is legislation. So we are not in the territory of Section 29.1b, because we are not concerned with an international agreement to which the UK is a party. We're concerned with European legislation produced by the European body of which the UK is a member. Something so very different. Finally, the respondent puts its case on the basis, well, even if that's right, you can't stop us, as they put it, relying on the statutory defence. But that's a rehearsal by different means of the case promoted under Section 29.1a, because it is a statutory defence to a statutory cause of action. And if the claim is for breach of contract, it is not a claim for damages under Regulation 15. Again, if one goes back to basics. This is all as it should be. One would not expect Regulation 15 of consumer protection legislation see the references to providing consumer protection in the CJEU cases, to which my Lady Arden has referred, and I've taken the court to the additional case, and there are plenty of them in the bundle, to have downgraded domestic protection for consumers in the context of personal injury or death would be indeed an extraordinary result. And it is not the case, because it is a claim brought in breach of contract. My Lord, can I then finally turn to Section 6? And Section 6 only bites if the court is against me in relation to that, and we are now having to address a defence under Regulation 15.2c2, which is that part that is relied upon by the respondent. Can I start by addressing the scheme of Regulation 15, by which I mean how it works, in particular in the context of fault-based breach of contract? And it may be helpful again to have Regulation 15 before the court, which is at page 434, so Authority Bundle 1, tab 9, page 434. Lord, I've already made a submission that liability under Regulation 15.2 arises where there's been a failure to perform or improper performance of the contract, for which one has to turn to the contract. See the judgment of Lord Justice Longmore in the Hone case. In a case such as this, the claim for breach of contract is based upon fault. That is, the failure to perform the service with reasonable care and skill. Regulation 15.1 makes clear, and can I invite the court back to its wording, that the tour operator is liable whether the relevant obligation was to be performed by the tour operator or, open inverted commas, by other suppliers of services. So where there has been a failure to provide the obligation, as here with reasonable care and skill, and the obligation was not performed by the tour operator, it was performed by the other supplier of services within the terms of Regulation 15.1, or then described as another supplier of services under 15.2. You see it. The other party to 15.2, other party to the contract is liable to the consumer for any damage caused to him by the failure to perform or the improper performance of the contract, unless the failure or the improper performance is due neither to any fault of the tour operator nor to that of another supplier of services. I'm going to come to the because and the rest of it, but just pausing at that point. It necessarily follows that the fault has been fault by, under 15.2, another supplier of services. It could be no one else, because there has been a breach of contract. If there hasn't been fault, and this is part of, in my respectful submission, the force of the point being made by my Lord Hodge, when looking at Clause 510b as a whole, if there hasn't been fault, there hasn't been a breach of contract. So we don't get into it because, as we know from Hone, the first thing you've got to do is look to the contract and see whether there's been a breach of the contract. So if it's a fault-based breach, and we're now looking at Regulation 15.2 at all, it's because there's been established fault giving rise to a breach of contract. If the fault hasn't, it's occurred by someone, the fault, someone or something, one looks at the company, but let's call it someone for these purposes, that someone is defined. It's the other supplier of services. And it doesn't matter whether the other supplier of services is down a contractual chain, gratuitous provider of the service like the yodeler or whoever. It doesn't matter, but it's the other supplier of services. So given it's been established in order to have a breach of contract that there's been fault by another supplier of services, it follows inevitably that the defence under A, B, C or C2 cannot be engaged because we have not been able to show that it is due neither to the fault of the other party nor another supplier of services. They now turn to the words because and what follows. We recognise that the defence goes on and says because, and then it says A, B, C and sets matters out. And so it's said against us, well, fault is defined by A, B and C. But if that were right, the word fault would add nothing. And it would simply have said, Regulation 15 would say, the other party to the contract is liable to the consumer for damage caused by the failure to perform or improper performance of the service, unless A, B or C. But it hasn't. It's talked about fault, unless there's no fault.
It doesn't define fault, but it may define, for the purposes of the defence, the absence of fault. The improper performance is due due not to fault because.
I do see that entirely.
But the
idea that the fault is defined by that which follows. But
yes, but because if that is correct, that gets around all the problems of vicarious liability and the captain of the sea vessel and so on, because one would not you would not be able to bring such behaviour by the captain of the sea vessel, negligence by the captain of the sea vessel, into any of the enumerated examples there.
My Lord, yes. But may I go one step back, which is it's referenced by the respondent as a statutory defence. It is a statutory defence. It's a derogation from that which is set out at 15.1. As a derogation, under European law, it has to be construed restrictively. And we've referenced a motor directive case. The point taken against us is a motor directive case. I say matters not. This is very ordinary European law principle. But we referenced the Candlin case. It's Authority Bundle 1, tab 14, page 527, in which the European Court says, however, as it's a provision which establishes a derogation from a general rule, the second subparagraph, Article 2.1, this is of the motor directive, but it matters not, must be interpreted strictly. That's a very ordinary rule of construction. Furthermore, and I've taken the court now to that passage of the Advocate General Designer in Leitner at para 26, the reference for which was its Authorities 1, tab 16, 588. In the event of any doubt, the interpretation most favourable to the consumer must prevail. So it cannot be a defence that's read to provide a means of avoiding liability where the breach of contract involves a finding already made that the supplier of services has been at fault. Is to read it favourably to the tour operator, which is not how it should be construed. Secondly, can I emphasise that the defence is not available to the respondent whether the supplier of services is deemed to be the hotel or inn. It matters not for these purposes. There has been fault by the supplier of services. If the supplier of services is N, then, as my Lord Hodge has observed, Section 15, or Regulation 15.2c2 cannot be engaged because, of course, N could foresee and forestall and was at fault. If it's the hotel, then the hotel is the supplier of the services, and the services have been supplied with fault, from which it follows that the hotel is in that position of, for these purposes, and it's not a principle of vicarious liability. It's a principle of recognising that if it is the supplier of services, those are services which it, as the supplier, could have foreseen and forestalled and was at fault in relation to. Because we're now looking at services provided by N, but saying that the supplier is the hotel. So you can't separate them out to the advantage of the tour operator.
So could you run
yes,
that point again, please?
Yes, my Lord. The thrust of our point here is that the fault has occurred. The fault lies with the supplier of services. That's how. The only way you can read 15.1 and 15.2. So when there's been a breach of contract, who's the breach been by? It's been by what the regulations called a supplier of services. That fault, at one level, one says it's N's fault. It's not the hotel's fault, it's N's fault. But if you're saying the supplier is the hotel, then the hotel embraces N's conduct. You can't have it both ways. You can't say, we're the supplier, the hotel, but we had nothing to do with N, because in that case, you're not the supplier of the service that N provided. If you're the supplier of the service that N provided, you are N for these purposes. You are responsible, not under the principle of vicarious liability, just under an ordinary interpretation of Regulation 15. This is why if you've a cleaner, you don't need vicarious liability, because if you've operational negligence in a cleaner, and the cleaner pours some liquid on the floor by mistake and someone slips on it and injures themselves, it's our case that there absolutely has to be a finding of breach of contract. You might say it's working the wrong way round, but one has to understand the purpose of this regulation as consumer protection. That is its primary object. If one says, well, the cleaner is the supplier of the services for these purposes, then the cleaner's at fault. But if one says the supplier of the services is the hotel, then the hotel has supplied the service that was conducted faultily by spillage. So it can't now separate itself out from the cleaner because it is the supplier.
Maybe the supplier of service, but doesn't that lead to the question whether the event could have been foreseen or forestalled by that supplier?
Well, Lord, no, because go back. There has been fault. At one level, you could say, well, the fault's by the cleaner. At another level, you could say the fault's by the hotel. But the fault is by the, open inverted commas, supplier of services. So if you're saying the supplier of services is the hotel, then the hotel has been at fault. You can't have it both ways. That's not to read this restrictively. That is to read this in the way most favourable to the tour operator, by saying we supplied the service, but we certainly aren't taking responsibility for it. That's all the wrong way around, because what it's actually saying, 15.1 is, the other party to the contract is liable to consumer for the proper performance of the obligations under the contract, irrespective of whether those obligations are performed by the other party or by other suppliers of services. So if the other supplier of services is the hotel that's provided cleaning services, those cleaning services have been provided faultily, then the hotel is at fault. The hotel could have foreseen and forestalled and all the rest of it. But it says an event which, even with all due care, in other words, showing that there must have been all due care, because otherwise they're at fault. But there hasn't been due care because the cleaner renders, if you like, the supplier of services at fault. To take advantage, in a complete way opposite to restrictive reading in favour of the consumer, to take advantage of the fact that you've chosen to place one set, you were identified as a supplier, someone to whom no obligations attach, or limited obligations of direct liability only. Not for vicarious liability, but it's not vicarious. It's just liability for the supply of the service. That's the point. It's not our suppliers. This Court of Appeal majority approach of let's look at who's in a contractual relationship and say our supplier. It's not our supplier. It's the supplier of the service. And the service that is conducted faultily means that the supplier has been at fault. Doesn't matter who you define as a supplier for those purposes. You cannot put a wedge between them.
So if one of the employees was moonlighting as a Pilates teacher, a self-employed Pilates teacher, that person would be the supplier in respect of services as a Pilates teacher. And
Absolutely.
so suppose that the Pilates teacher in that situation said that he was in fact performing the service on behalf of the hotel, and so represented, by whatever words you like to use, that he was not himself a supplier, but the hotel was. Does that change the particular?
No, my lord, not at all. No, this is for the court to determine, not for someone to say, by the way, this is how I choose to say I'm representing myself. But again, it doesn't matter, because if I'm meeting frowns in relation to submission, one simply has to look at the position of, exactly as your ladyship has indicated, a cleaner who's self-employed and a cleaner who's an employee. A cleaner who's self-employed, an independent contractor, plainly is supplying the services. It's very difficult to say the hotel is supplying the services of an independent contractor. Or one could, but it doesn't matter. But let's just go with that. So that would give rise to no opportunity for a defence. But a cleaner who is employed would then give rise to an opportunity for a defence.
And at the end of the... Yes.
All that matters is there's been fault in the supply of the Pilates, the cleaning, whatever, the waitering, the entertainment services. It just doesn't matter.
What is the nature of the hotel's fault if the negligence is that of the cleaner?
Sorry, my lord.
What is the nature of the hotel's fault if the hotel is the supplier and the negligence is that of the employed cleaner?
That's the nature of the fault is mirrors the fault of the cleaner, because if the court determines that the supplier in that context is the hotel, then it's the hotel that has been at fault, and one might just say brackets through its employees' conduct, but it doesn't matter. Otherwise, the court is separating them out so as to divest an employer of responsibility, remarkably in circumstances where an independent contractor would lead to liability.
Your essential point is, if it comes within the rubric supply of services, and there has been a deficit in the supply of services, that gives rise to liability.
You cannot rely on a statute of defence. There is by definition fault.
So if there's an option as to whether the supplier was N or the hotel, and the result of characterising N as a supplier was that the consumer would be without a remedy, would it also mean that your application of the presumption that doubts of interpretation should be resolved in favour of the consumer?
My lady,
mean
would,
that
but if it was N, then absolutely there couldn't be a defence, because N didn't take reasonable care and N could foresee and forestall his conduct. So that would be
the other way around.
Hopeless for the respondents. The respondent says it's the hotel, so the hotel is therefore the supplier of services, but bears no responsibility for the supply of those services. That is not consumer protection legislation. That is the antithesis of it.
So
But the hotel would bear responsibility for the negligence of an employee, because the definition in 15.2 of the limitations on fault, as I presented it in the 3 enumerated paragraphs, would not protect the hotel against the negligence of the employee.
No.
And
Forgive me if I've missed the force of your lordship's observations.
yeah, because if one was looking at C2, an event which the supplier of services, even with all due care, could not foresee or forestall, any employer can foresee the possibility of negligence on the part of the employee.
Well, my lord, so that's the crooked timber reference in Muhammad by Lord Dawson.
Yeah. So, I mean, another way of looking at this provision is to say that the vicarious liability and negligence of employee doesn't come into the picture simply because of the narrow definition of the absence of fault. But that still leaves open the question whether, if the hotel is the supplier of services, whether 15.2c2 might bite, if we're not dealing with something that was foreseeable and forestallable with the exercise of all due care.
Lord, in the judgments below, the case had been put, or at least I think it may not have been pursued at trial on the basis that the hotel was what they call directly liable. So it's never been a case of hotel is directly liable. The hotel should have recognised this was an employee who was unfit for his job and liable to commit a sexual assault, etc. We're not concerned with that point. And may I forgive me, but I'm going to have to just move on.
Well, please just move on. I just wanted to put the point
want
to
of
you.
time at this stage. I do want to take you to a case on force majeure, and I take it to you because 15.2c1 is the force majeure defence. And that one sees this when one goes back to Article 5 of the Council Directive at page 300, para 2 third indent. It mirrors the para 2 third indent. Failures are due to a case of force majeure, so it's page 300. Article 5, para 2 third indent, and the court will see force majeure, and then that's defined if you go just above Article 5, just above para 7 of Article 6, do you see 2? And you'll see it's defined for reasons of force majeure, which is obviously an autonomous European term, i.e., as the court sees, unusual and unforeseeable circumstances beyond the control of the party, the consequence of which could not have been avoided, even if all due care had been exercised. Now, there is a case...
This is MS 300, yes.
300,
Yes, thank you.
my lord, yes. Sorry, my lord.
I've got to go Article
It's my
5
fault
too.
because I'm now rushing. But it's on 300. You've got Article 5.2 third indent,
Yes.
and it says, as defined in Article 4.6, if you just go above Article 5, up above 7, you get to Little Roman 2, which starts cancellation. And then you'll see that's the 6. It says for reasons of force majeure, and then it says i.e., it defines it. So that has all been followed through to Regulation 15. McNichol and Minister for Agriculture is a case at Authority 1, tab 17, 620. In which the European Court of Justice has held that where a contracting party's subcontractor commits fraud, bad luck. You cannot rely on force majeure. CD analysis from paragraphs 11 to 14, so this is page 620. 620. Not all of which I've time to read out, but right at the bottom of 13, or partway through 13, the same rule applies where the first purchaser entrusts the exportation of the goods to a third party. The third party concludes a contract of carriage for that purpose with a fourth undertaking. In such a case, the purchaser must therefore be answerable to the intervention agency for any unlawful conduct or negligence on the part of those two undertakings. That was his subcontractor. Such circumstances cannot be regarded as unforeseeable in contractual relations and are therefore an inherent part of the commercial risk. See the observations of Lord Hodge. That's the point. When one construes Regulation 15.2c2, which one of course does with regard to what's set out at 15.2c1, we expect coherence and consistency in our construction of the domestic directive, regulation which follows the European directive. That's how far the European Court has gone in saying that's not unforeseeable. Ditto here.
But in respect to the term supplier, and I'm asking this quickly,
Yes,
it is a term of the directive, and therefore, is it not possible that it bears an autonomous meaning rather than a securicore meaning, so as to give the consumer the choice of whether it's N or the hotel?
Well, yes, it's certainly that which is most favourable, and it may change. Lord Justice Longbourn said it's maybe context-specific, but there's been no application for reference to Europe, and just part of our case is we don't get to the regulations, but another part of our case is it doesn't matter for these purposes, because whichever way you look at it, N or hotel, they're on the hook. They do not have a statutory defence. Forgive me for having worked so hard to drive with that submission. I won't, for these purposes, therefore, go to the Court of Appeal majority decision. The respondent I infer, this is inference, I infer that the respondent is sensitive to the challenge that these regulations need to ensure that there is liability for operational negligence by, say, a cleaner, taking a very standard case. I infer that because the respondent has sought to create, their words, formulate a special rule of attribution. That's their case at para 109, page 137, which I infer, but it's a matter for the court to discover, is a consequence of their recognising that you've got to find operational negligence leads to liability, or it's not consumer protection legislation at all. That's exactly what it's supposed to achieve. A special rule of attribution based upon a criminal act of an employee falls foul of A, reading the defence restrictively, B, if in doubt, interpreting the regulations in the way most favourable to the consumer. What it amounts to is an attempt to superimpose a specific English rule of attribution applicable in an entirely different context in the case law into a regulation that has to be interpreted consistently with the autonomous European meaning of a council directive. It's a no-go zone. ABTA also, I infer, recognises the difficulty of an interpretation which does not lead to liability of the tour operator for operational negligence by a cleaner. And it has proposed that the tour operator is liable where there is negligence by an employee of the hotel, which would render the hotel vicariously liable. That invitation to the court should be resisted. The language of Regulation 15.2 is to say there is no liability if the other supplier of services has, even with all due care, couldn't foresee or forestall. Vicarious liability is a public policy principle of strict liability, which will vary from country to country in sometimes profound respects. It cannot be squeezed or incorporated into a test which has nothing to do with that principle. This is a test that says if you're not at fault, vicarious liability is a no-fault liability. So it can't be squeezed in, nor should it. Again, when one stands back, nor should it. It would add a level of complexity that would require every claimant holidaymaker to go to the foreign law to understand what vicarious liability means in the foreign country in which they've been injured and to produce expert evidence in relation to the same. We are now so far removed from the clarity provided by English domestic contract law as to highlight and expose how we must have gone wrong somewhere on the journey. Because English domestic contract law provides the very simple, effective remedy, single remedy, to the holidaymaker in their country under their law. The appellant brings her claim in England under English law for breach of contract. She doesn't have to have regard to the nuances of the contractual relationship between a cleaner and a hotel at all, let alone the further step of establishing vicarious liability. We don't go to the regulations. If we go to the regulations, they cannot be relied upon in a fault-based claim.
Well, that seems a very good rhetorical flourish on which to finish, Mr. Weir.
I need no encouragement, my Lord.
Thank you very much indeed. Ms. Dean? Mr. Ordland.
My Lords, my Lady, may I start by outlining in short form the propositions which I go on to develop. On issue 1, our case on breach of duty is based on common law principles of contract. We say we were not under a contractual obligation to provide guiding services around the hotel at all times of the night and day by all hotel employees, whether customer-facing or not. We say that for three reasons. First, there was no express term to that effect, and no such term should be implied as a matter of law. Second, if contrary to that submission, there is a term by which Kuoni agreed to provide such services, and that is to be implied into the contract, N was not providing such services at all, both as a matter of fact and as a matter of law. As a matter of fact, on the findings made by the judge at first instance, to which Lord Hodge has already referred, N was at all times luring. We say that is not guiding. Furthermore, any guiding was a mere pretense, a cover for his grotesque criminal enterprise. As a matter of law, we do rely on the general rules of attribution. Here, we are operating in contract, and so it is the rules of agency to which the court must have regard, and the notion of authority, by which not all acts by servants or agents of a legal person, and it is legal persons whether one is having regard to Kuoni or the hotel company, that are in issue, not all acts by agents can be attributed to such legal persons. And on the facts and findings in this case, we say N had no such authority, actual or apparent, to do what he did. We further say that he was never providing a contractual service at all. At all times, he was acting dishonestly, contrary to the interests of both his employer, the hotel, and the tour operator. He was, we say, acting in a purely personal capacity. And third, and lastly, on issue 1, even if your lordships were to find that he was providing a contractual service by guiding prior to the assault, come the assault, he is not doing anything of the kind. Put simply, the assault cannot be construed as guiding, cannot be construed as a breach. Here too, we rely on the rules of attribution and say that even if N had authority to guide, he most certainly had no authority to commit the sort of criminal act with which we are dealing here. It is agreed, as your lordships will be aware in the statement of facts and issues, that the act of N, he was acting alone. And we say alone in this context means exactly that. He was acting in his personal capacity. If your lordships are against us on issue 1, then when it comes to issue 2, namely the defence, we say this: Kuoni can avail itself of the defence in contract and under the regulation. It has been common ground that clause 510 is intended to bring into effect the regulation, and at all times the claimant has brought her case under both the regulations and in contract. By regulation 15.2c2, we say N's acts are excluded. The availability of that defence is principally a question of statutory construction, and on a proper construction of the defence, we say it was intended precisely to be available in circumstances such as this, where it is agreed that there is no fault or failure to take any reasonable care by both the tour operator, and the hotel. Although there were many such allegations at the outset of this case, all of those were conceded by the time of trial, and that too is set out in the statement of facts and issues, and that was because neither the tour operator nor the hotel could reasonably be expected to have foreseen or forestalled the acts of N. We rely in this context on the wording of the directive and the regulation which it brings into effect against the background of the travaux préparatoires. And we say that the supplier is clearly any supplier of contractual services which we are obliged to provide under the holiday contract. But we accept that it's not only a supplier in a direct promissory relationship with us, but it includes those in an indirect relationship, those in the contractual chain descending from our original contract. But it does not include all the various servants and agents of those legal persons in the contractual chain. To the extent that it is necessary to do so, we do invite this court to devise a special rule of attribution following principles in Meridian Global on the special facts of this case. Rules of attribution are always context specific, and the rules that are applicable in this case will not necessarily be applicable in other cases, certainly not in cases of operational negligence. But such a rule, if required, we say, drives one to the conclusion that the only supplier intended is the ones for which I've already identified, and that, secondly, N's acts cannot, for the purposes of the defence, be attributed to the tour operator or the hotel. My Lords, those are the propositions I propose to develop, and I'd like, before the adjournment, to start by a short exploration, or with a short exploration of the travaux préparatoires to the 1990 directive, before turning to those issues in turn. And for this purpose, your Lordships will need both Volume 1 and Volume 3. My Lords, before I start taking you to a few of the travaux, in outline, whilst the appellant puts her case in this way, that the principal objective of the directive is consumer protection, which requires a wide interpretation of 15.1 insofar as you're invited to impose liability, and a narrow interpretation of 15.2 insofar as you are invited to apply the defence, with the consequence that we will be, the appellant says, liable on the facts of this case. We say that an analysis of the travaux reveals 4 propositions, which are somewhat different. First, consumer protection, we accept, is a clear objective, but it was not the sole objective of this directive. This directive also had as its objective market harmonisation and the internal market, and that required the proposition that both interests of the consumer and the interests of the travel industry should be protected. That required striking a balance between the consumer and the travel industry. Second, Article 5 itself moved away from an initial proposition of a strict liability regime to a fault-based regime, in which the tour operator could avail itself of a number of defences where there was an absence of fault. that, we say, is in itself a reflection of the balance which was struck in the legislation of this directive. Third, whilst the legislators in the course of its history considered whether to bring into its scope some form of liability for criminal acts, they ultimately resolved that they should not, that this directive was not the place for such liabilities. And fourth, suppliers, for the purposes of Article 5 and Regulation 15 by necessary inference, were envisaged to be suppliers, as I have said, in a chain, in the contractual chain descending from the tour operator, not any supplier whomsoever, even if an agent of such legal person. The place to start, please, my lords, is the initial proposal for the directive, which you'll find at Volume 1, Tab 3, MS 323. And
Sorry, Volume 3, Tab
323, but my lords, Article 5, to which I invite you to refer first, is at 323, I'm sorry. Lords, this was the initial proposal of Article 5, and I invite your lordships to read the article. It's short. 5.1, which subsequently became the article to which your lordships have already referred, initially provided that the services which under the contract are to be provided for the consumer, whether by the organiser or by a third person, shall be rendered punctually and efficiently. And then 2, that vis-à-vis the consumer, liability for any deficiency in the provision of those services lies either with the organiser or with the retailer. No definition, no use of the word supplier in Lim 1, only a third person, wider in scope. No express reservation, which we now have, of the right of recovery against such suppliers. And clearly, no defences, a strict liability regime. And whilst we're here, I invite your lordships briefly also to look at Article 7, because this becomes relevant to their consideration of criminal liabilities. Article 7, on the same page, initially provided, member states shall ensure that organisers cover by means of insurance such part of their liability under this directive as is insurable, and that there is available in each of their territories a guarantee fund for payment of claims sustainable under this directive which remains unpaid from some other source, i.e. when no compensation is available from the organiser.
Well, if Article 5.1 had remained in its original formulation, would Kuoni have been liable in this case?
Well, Lord, may I pause to reflect on that
You
point?
can tell me after the short adjournment.
It's Article 5 has changed substantially. May I reflect on that point before I answer it? Lord, could we then turn to one or two of the reports of the parliamentary committees who were invited to report on the proposed directive? The first one I'd invite your lordships to have regard to is one which both parties place reliance on, and it's in the following tab 4, in the same bundle. This is the report of the Economic and Social Committee of February 1989. Now, Lords, without turning to it, it's important to observe that this report is expressly referred to in the preamble to the directive as in its final form as being part of the legal basis for the directive. Lords, first of all, at the first page of this report, the two paragraphs I'd invite your Lordships to have regard to are paragraphs 1.1 and 1.4 at the second indent
Could
of
you
the
give
top
us the
of the
indent
second
number?
column.
The MS number, please.
MS 325, my Lord.
25.
1.1 and 1.4 second indent, both of these appearing under a section entitled General Comments. Lords, we say that those contain a clear expression of the balance between the needs of consumers and the travel industry. Lords, over the page at 327, the committee reports on the proposed Article 5 at paragraph 2.8, MS 327. First of all, at 2.8.1, in the second paragraph, the committee recognises that simple consumer access to justice is essential for the completion of the internal market, and notes that the tour operator is in a much stronger position than the individual holidaymaker to recover damages from hotels or transport carriers, particularly where health and safety are concerned. Pausing there, I'll develop this further, but this is part of the indication that in their minds in the course of this legislative history, the people being identified as likely suppliers are the sort of legal persons to which I've referred, not individual agents. 2.8.2, reference to Article 5.2, the committee nonetheless feels that the Article 5.2 should make it clear to the consumers where liability lies in individual cases. Further, the committee regrets that neither in Article 5 nor in the explanatory memorandum does the Commission address the important associated questions of limitation of liability, whether by reference to the contract of carriage or a single maximum figure, and the relevance or otherwise of fault or negligence on the part of the tour operator or his subcontractors.
The original proposal of the Commission was a form of strict liability.
Correct.
So there's a difference of view here.
Absolutely, and my lady, precisely that's why we say this history is important to see the change between the strict liability to the fault-based regime and what lay behind it when one comes to interpret who should be a supplier, amongst other things, for the purposes of the regulation. My Lords, the next report is the report of the Committee on Environment, Public Health and Consumer Protection, which is now in volume 3, I'm afraid, tab 44. And, my Lords, there are 2 pages to which one needs to refer. In manuscript, it's easier to have one's finger in both. Electronically, it's rather more of a challenge. It'll involve scrolling up and down. But the 2 pages, my Lords, are 1145 and 1154. And they're related in this way. They are amendments to an article, a recital and an article respectively, namely 18b, recital 18b and 4b, and recital 18c and article 4c. Starting, my Lords, at 1145, the amendments, number 2 and 3, are to insert new recitals. First, whereas injury and death to travellers can result from inadequate or defective accommodation, the proposal is that it is necessary, dropping down, to provide redress for such risks without fault. Amendment number 3 related to criminal acts. Whereas many member states provide compensation for victims of criminal acts, the pursuit of such compensation is often difficult, and jumping on, thus, such legal costs should be covered by compulsory insurance. And then when it comes to the proposed amendments to the articles on 1154, we see that those are carried through at amendment number 24, proposing a new Article 4B. Member States shall ensure that where a customer is injured in the accommodation, the customer shall be compensated without the necessity to prove fault, either directly by the organiser or the retailer or by means of insurance. And then 4C, relating back to recital 18C, the Member State shall ensure that where a customer is injured as a result of criminal acts, the contract will include insurance cover from the cost of legal expenses in pursuing the right to compensation. Now, my lords, we say that those two suggested amendments, which did not ultimately get carried, are revealing. First, the recommendation here of itself assumes that such compensation in Amendment 25 would not be available from the tour operator under the directive, hence the provision for providing for legal expenses cover, essentially. Even though, at this stage, what is being envisaged is strict liability for injury sustained in accommodation and liability for criminal acts. My lords, I'm conscious of the time. The next document, I'll simply give you the reference. Those recommendations were incorporated into the revised text proposed by the European Parliament, and the references for that are Volume 3, Tab 47, 1195, it begins, and the recitals and the articles you'll find at 1196 and 1200, page 1200 respectively. Those recommendations were carried forward, but ultimately not put into force. They were dropped. My lords, that may be an appropriate moment.
We'll sit again at 2 o'clock. Thank you very much.